Good afternoon, everyone. Welcome to our 1 o'clock webinar to discuss employment law related topics and items. My name is Ryan Morgan. I am one of the practice leaders of the employment law group here at Morgan and Morgan. I have been practicing law personally for about 16 years, 13 of which has been exclusively in the area of employment law. I manage, along with a partner of mine named Andrew Frisch, a team of approximately 30 lawyers scattered throughout the country in Morgan & Morgan offices who handle all types of employment cases. And we probably have about double that number when it comes to staff to assist in claims we are pursuing. As I said a second ago, we handle almost the whole gambit of employment type claims. This could be everything from your regular unpaid wages where, hey, I was missing some paychecks or not getting paid the commissions I'm owed, to class action cases involving overtime pay or could be even minimum wage payments that are owed, server type cases. We also handle discrimination cases. So where if you believe you have been discriminated against based on protected characteristics, which I'll get to in a second, then you can have a claim for discrimination. We also handle retaliation cases, and that would include cases where if you have become a whistleblower and you have objected to certain illegal things the company is doing, or if somebody's being treated for example, if you've been witnessing sexual harassment in the workplace, and you go and complain about it and raise a question about it and are retaliated against, that's illegal. That law contains an anti-retaliation provision. That means you cannot be retaliated against for bringing those types of claims. We also handle FMLA claims. We also handle ADA type claims, which is the Americans with Disabilities Act. So if you've got some sort of disability where you need a reasonable accommodation, you can request that of your employer, and they are supposed to be what they call the interactive process, where your employer discusses it with you and gives you an accommodation that is reasonable in nature. And if they don't confer and interact with you, or let's say you bring up this accommodation request and in turn they fire you, well, now it becomes a retaliation claim under the ADA. That also includes an anti-retaliation provision. We also handle sexual harassment cases involving individuals who unfortunately have been harassed at the workplace. We handle what are called USERA cases. Those are for typically for military members who are being treated and discriminated against basically because of their military status. We see this with a lot of individuals who work in the National Guard and have to take certain time off to fulfill their Guard obligations and get discriminated against or terminated in some situations by their private employers. We also handle even Title IX cases. That are employment-related type cases involving schools, universities, and things of that sort. So with our group, we do handle a very wide range of cases. We have numerous subject matter experts that work within our group who review each case that comes in. Each inquiry is going to be reviewed by a subject matter expert, and the majority are also reviewed by attorneys to see if we can assist or not. Like I said, we've got almost 30 lawyers that do these types of cases exclusively, kind of scattered throughout our offices of the Morgan & Morgan footprint. We do handle cases nationally. I personally have cases in California right now, and New York, and Florida, and Chicago right now, all over the place. So we'll travel, not a problem. Most of these laws, to kind of start big picture for just 1 second, of employment protection laws start at a federal level. The United States Congress and the presidents have signed numerous bills over the last 100 years affecting employees and protections for employees. So the federal laws that are in place provide a base. They provide a floor that everyone's got to follow. And then if you start going down one step further, states oftentimes have additional additional protections for workers as well. As an example, here in Florida, Florida has what's called a workers' compensation retaliation statute. So if you're an individual who gets hurt at work and you get injured, you cannot be retaliated against for bringing a claim. That's not a federally protected right, but it is a right that is protected here in Florida. You also have to look at even some states and counties. For example, in New York City has its own rules and regulations that even provide further protections for employees. So the reason I bring this up is if you're someone who's facing a situation, you're facing some uncertainty at work, is start with the federal level, but then also you can also look into state or individual city protections that could apply to your situation. So don't hesitate to always look around first on the internet. One good thing about the employment law area is there are so many publicly available websites and information. For example, the EEOC. A lot of people have heard that term before. What does that mean? That's the Equal Employment Opportunity Commission. They are the federal agency that oversees the discrimination laws, for example. So if you go to their website, you will find lots of information if you have questions about those types of situations. But in a minute here, we're going to open it up to some Q&A. I did want to kind of just give that brief background here of who I am, what my group does here, and I'm going to try to answer as many questions as I can from people. So please don't hesitate to send some questions in or send them in the chat, and we can do the best we can here. So I do see a question that is listed here regarding whether employers are required to provide sexual assault training. Unfortunately, it's not a complete yes or no answer. Employers don't have to provide it from day one and have to do steps 1, 2, 3, 4. Now, where there's some exceptions is if they know there are some potential issues regarding sexual assault or know of circumstances that may lead to it, or I don't want to say promote it, but something along those lines, then yes, there is some duty to inform employees, have discussions with managers. Certainly it's a good practice. And you will see in a lot of companies that managers, supervisors, HR individuals from human resources will be given those types of training to deal with those situations. If you are someone who is facing a sexual assault type issue, here's a piece of advice, and this actually relates also to any individual who believes they're getting discriminated against for some reason, is you need to bring it to your employer's attention. Not just because it's the right thing to do and we want to get the situation corrected as soon as possible, but legally you need to do it. A lot of these laws, including the discrimination laws and the sexual harassment laws, actually require an employee to go to HR, go to a manager, go to the owner of the company and bring up this complaint. The theory behind it is you need to give the company an opportunity to fix the situation and do the right thing. Now that can be uncomfortable, obviously. And I've had many clients who said, hey, my harasser is my boss, or the harasser is the owner or the HR person. And so obviously it's going to be very fact specific based on any person's individual situation. But what you have to think about is, okay, if it is the HR person, okay, well then go to your manager, go to somebody else higher up the chain. If it is your manager, well, then that's when you would go to the HR person. And it's good to typically put these things in writing too. I know that's a concern. It's scary because you don't want to face retaliation, but I've had many cases where it's not been in writing, and it can be a difficult item to prove when someone says, hey, I sent this email, or I disclosed I was being harassed, and the other person says, nope, that never once came up. So putting it in writing helps. It also helps protect you from retaliation. So if you are retaliated against and fired, oftentimes from our perspective, the lawyer's perspective, when we're looking at cases, the more straightforward claim, if you will, that we can really beat up the other side with will be the retaliation case, because they'll debate and they'll deny that any of the harassment occurred, but what they can't deny is that you emailed about it to somebody and then a day later you were fired. How are they going to explain that? The timing of it is just too suspect. It doesn't make any sense to try to say there was some other reason for it. So remember, keep things in writing. For discrimination type claims, really any types, FMLA issues, harassment issues, it's good to put these things in writing. Remember, you don't have to write a novel. It doesn't have to be War and Peace. In fact, I would probably advise the opposite. Keep it very focused and very to the point to HR. Hey, I am having an issue with my boss so-and-so. They are harassing me. They are touching me. They are making me uncomfortable. Please help. When can we meet to discuss about this? Very straightforward and to the point, so that they can't dance around and say it was about something else. One thing I did want to mention as well about my firm is we handle all cases on a contingency fee basis. We do not charge upfront for anyone to hire us. You never have to write us a check for our hours or our costs or anything like that. That is our model. Our model is we get paid on the back end, and it's only if we are successful in our claims. You'll see in the employment law arena in particular, a good number of firms that do charge by the hour or do charge cost retainers to hire them. And that's fine and dandy. That's their model, and that's what they are used to. But ours is different, and we made the decision as a firm a long time ago to handle 100% contingency fee-based litigation, and that, as John Morgan likes to say, pay for results, not for hours. There is a question I see on the chat about would our firm take on an age discrimination case? We absolutely would. We see many age discrimination cases come through the door, unfortunately. Some of them can be very overt, where literally we had one case years ago where someone put in an email that they had, "I'm sorry, so-and-so, you no longer fit the youthful image of our company. We have to let you go." That's pretty clear cut. I mean, I'm shocked somebody put that in writing, but you know what? It's amazing the things we'll see in writing. Then there'll be these age discrimination cases where it's less clear. It's something you really have to kind of piece together. Companies going through layoffs, or over time they've laid off a good number of employees. And I'm just making up an example, but if there's 30 people who are on the same position, same levels, they start laying off folks one by one, and it all happens to be the older folks. Well, after a time or two, it's looking a little suspect. And to clarify one thing, under the age discrimination laws, the cutoff for age discrimination is 40 years of age. Really isn't that old. Now that I just turned 41, I can say that. But it is 40 years of old. So something that we will look at as the lawyers is, okay, if you are 50 years old, for example, and you were laid off and you suspect age discrimination, is first questions we're going to be asking is, okay, well, what's happened to others in your position who were below 40? Are they getting laid off? Are they being treated the same way? If they are, it might be more difficult to prove age discrimination. But if you can show and allege and prove that, hey, the folks over 40 are disproportionately being terminated, let go, picked on, whatever, the folks under 40 are being left alone. Okay, we're starting to see a pattern of age discrimination. And I do see this question as well in the chat here about this individual saying you're not even getting interviews for jobs because of your age. Those can be cases. Those are called failure to hire cases, where somebody has failed to hire you because of a protected characteristic. We're kind of focusing on age. I'll come back to this fact scenario for a second, but I did want to take one step back. People will ask, "Hey, I've been discriminated against, or I'm being picked on." There are only certain categories that are protected under federal and state laws. these are, and again, some state laws might protect more, some city laws might protect more, but this is what the federal laws and for the most part, most state laws will protect is, of course, age. We're talking about that one, your race, your national origin, which is a little bit different than race. You could be an African American, but you may be here from the States versus somebody who's specifically from an African country, and you will see sometimes the very, very specific national origin type of cases. Your gender, obviously male, female. Religion is a protected category. And then as of last year, based on the Supreme Court's opinion in Bostic versus Clayton County, sexual orientation is also now a protected category under Title VII, which is the formal discrimination laws on the federal level. So coming back to the question about the age discrimination case and the failure to hire. So to answer your question, sir, on that specific case, what I would be looking at and what our lawyers are just going to be looking at is how are we going to be able to prove that? We get cases like this where that is what individuals will suspect. Hey, I think it's because of my age. To really break the case open and have a really good case, getting some witnesses, somebody who will testify and say, hey, I worked for this company. We didn't want to hire so-and-so because we were only looking for people who are in their 30s. Again, I'm making up examples here, but try to jog your memory and help you in trying to find what kind of information is out there. What kind of information can you get to prove your claim? So it could also be somebody who is not necessarily within the company, but maybe a recruiter. I've seen those cases too, where you're utilizing a recruiter to try to get you jobs, and maybe that job said, oh well, hey, so and so is just too old for us. Okay, well, that recruiter's a witness. That's a critical witness to show that their failure to hire was based upon your age. I do see a question here about what if this happened 4 or 5 years ago? There are statute of limitations for basically every law. They are different. For example, wage cases, overtime cases are typically 2 to 3 years, depending upon the type of violation. For age discrimination and these types of discrimination cases, they typically are shorter. Some of them can be as short as 180 days, for example, in Georgia, because that's kind of the basic federal statute of limitations. Florida, it's a little bit longer. It could be 300 days or 365 days, depending upon the type of discrimination alleged. So 5 years ago, I feel pretty confident in almost every state that's going to be beyond the statute of limitations, unfortunately. But most of the ones that you will see range from that 6 months to maybe a year or two. FMLA claims, we talked about those. Those are typically 2 or 3 year statute of limitations. The difference you see in those 2 or 3 years is whether we on our side can prove the company willfully violated the law, and basically, intentionally. If it was kind of a non-willful, I don't want to say an accident because that's not the right word, but ticky-tack type of situation, or it's not a clear-cut violation, maybe then it's just the 2-year statute. But if we can prove, hey, these people really intentionally meant to violate the law, we can go back an extra year to that 3rd year. Looking through some of the other questions that we have received from other individuals, there were some questions about being fired for retaliation. And so I did want to cover for a moment, what does that mean? Because again, we get people who call in potential clients saying, I've been retaliated against. In the law, that has special meaning. To be a victim of retaliation, the first step is that you had to have made a complaint about something that is legally protected. So earlier we talked about if you are somebody who is complaining about sexual harassment, like you're witnessing this happening at your workplace to someone else, the harassment laws specifically provide protection to individuals who speak up about this. You are protected from retaliation. They cannot retaliate against you. Now I'm going to totally change the facts here to go to the other way. Sometimes I'll use the example with for myself. If I go to my own company here and I complain and say, you know what, I really wish we would give out free waters or free Coca-Colas to all the employees. And in response, my boss says, damn it, you're a complainer, you're fired. Well, did he retaliate against me for my comments? Yes, he absolutely did. Is that legal retaliation? No, because there's not a protected right for me to go ask and complain about, employees getting free sodas and free water. Now, I understand that's a silly example, but the point is you have to start with is what are you complaining about? Is it legally protected? You have a right under the overtime law to go ask for your overtime and ask about being paid for everything. They retaliate against you. That's legal retaliation under the overtime law. Talked about harassment. FMLA claims have retaliation provisions. ADA claims have retaliation provisions. Title VII, that's the discrimination law we talked about with race, age, gender, all of those characteristics. Retaliation is protected against from there as well, both if you bring a claim or if you go to HR and complain about you witnessing somebody else in a claim. Some states, not all, but some states do have what they'll call private whistleblower laws, like Florida, for example, has one. If you go to HR or whoever and you complain about your job and your company basically violating a law, rule, or regulation, those are the magic buzzwords, and they retaliate against you, then you can have a retaliation claim. Easy example I had from years ago was an individual was complaining. He made a complaint to his company about certain pesticides that the company was using in their line of work, which were illegal. They were illegal under federal guidelines, and they were not supposed to be used anymore. And they basically made up a BS reason to get rid of them and fired them. And we brought a retaliation claim under that private whistleblower law, and we're successful in that claim because that was an illegal act. They were violating a rule, regulation, or law in regard to what pesticides they can be used. Next question. There were some questions we also received about overtime and when you may be owed overtime, when you may not be owed overtime. So big picture here, starting kind of from the 30,000 foot view, if you will, is every employee, if you're an employee of a company, you are entitled to overtime unless you are exempt. And I'll come back to that in a second. The other exception we see more and more today is if you're not an employee, putting that in quotation marks, and you are classified as an independent contractor. People ask, well, what's the difference? How do you tell? There is a very large difference in the law. Employees are entitled to the protections of employment laws. They're entitled to overtime. Independent contractors are not. How do you tell which one you are? There's a 6-factor test that most courts will use to determine whether someone is actually an employee or actually an independent contractor. But a lot of it's common sense. Is think about, okay, if you're working for a company, they call you a contractor. Let's use this example, but you're working 50, 60 hours for this one company. They tell you what to do. They tell you when to come in. They tell you what work to do. They provide you the materials and whatever you need to do your job. That looks like an employee. Even though they call you a contractor, you look like an employee. You are acting like an employee. They are treating you like an employee. And so when the courts make these determinations, they don't look at what somebody's called. They look at what are the actual facts, what is actually happening, the actual relationship between the parties. So that's an important key point. We do have numerous cases we are handling, me personally, I'm handling, involving groups of individuals classified as independent contractors when we believe they should be employees and then entitled to the protection of the overtime law, for example, in my cases. So back to the overtime. Okay, so you're an employee, or you should be an employee. Are you then owed overtime? There are a bunch of different exemptions contained within the overtime law. If you are exempt, that means you don't get overtime. So I'll start with a couple basic premises. If you're an hourly employee, you are paid by the hour. So if you work 35 hours, you get your hourly rate by 35. You almost always, with very limited exceptions, should be paid time and a half for your overtime. They cannot pay you nothing. They cannot cut your hours. They cannot only pay you your regular hourly rate. We call that straight time. So if you're making $15 an hour and you work 50 hours, they can't pay you $15 an hour times 50. They need to pay time and a half of that $15 an hour. So hourly ones are a little bit more simple. And a lot of times what we'll see in those types of cases will be hours being cut, the straight time scenario we just talked about, automatic deductions from the time. For example, you still see companies that will automatically deduct 1 hour for lunch, whether you got it or not. And in fact, they usually know you're not getting it because they see you working through the day or you're out driving around traveling for the company doing work. Those are cases we handle as well. If you're a salaried employee, it gets a little bit trickier because then we do have to start looking into specific exemptions that can come up. One of the main ones would be what's called the manager exemption, the executive exemption. If you're called a manager, you actually have to manage 2 full-time employees yourself, and you also need to be involved in hiring and firing decisions. If you're a manager, again in quotations, but you don't actually really exercise management duties, and you sort of a glorified, hourly employee, but on a salary only, you're likely going to be entitled to some overtime compensation. Some kind of, again, more straightforward exemptions would be there is an outside sales exemption. So if you're one of those employees who's traveling door to door, business to business, making sales and doing things of that sort, unfortunately, you're not going to be entitled to overtime. So those types of exemption cases and these situations, I could ramble for hours about all the different exemptions that are out there. It's what I do all day, every day. But they are fact specific, and certainly we would love to take a look at any situation that you may have. And let me say this too, and remember this: when you talk to a law firm, whether it's us or anybody else, of course, we would love to talk and try to help out anybody's issues. But remember, it's confidential. This is a confidential process. When you contact us, we don't just go run to the company to start your claim. We are going to review it. We're going to analyze it. We're going to talk with you. You're going to talk with the lawyer that's assigned to your case and their team, their case manager or paralegal before we go there. So I've certainly advised clients and had clients who have come to us who said, listen, I'm not quite ready to move forward with my case, but I did want to figure out, is it a case first? And I have a few cases right now, I'd probably say 4 to 5, that we have started the process, but the client wants to wait a few months to try to go find a new job somewhere else before we actually start the case by going to the company and demanding certain items, whether it be records, money, whatever the case may be. So please remember that these are confidential processes. This is an attorney-client privilege communication. Even if you ultimately never hire us, it is still attorney-client privileged. Any conversations with a lawyer or a law firm, which may ultimately lead to representation, count as attorney-client privileged. So please don't be shy about asking questions or calling in about certain situations. And we'll get our subject matter experts and our lawyers on it as well. I'm looking through the list of any other questions that I've seen. If people have other questions, don't hesitate to type them in the chat. I just opened it up to make sure I had all the ones covered that I've seen. I know one of the questions we received right before this started was something we did cover a little bit about before, where somebody was feeling racially discriminated against by their boss and other colleagues, and what should they do? That is a classic example. Go to HR, make that formal complaint. I know it's uncomfortable, and I know it's scary, quite frankly, to do that because you feel like your job is going to be at risk. But again, there is that anti-retaliation provision. It does protect you in the long term from this discrimination and from retaliation. And I will say this, in my years of experience, there's always exceptions to rules, but for the most part, companies are usually pretty good about not retaliating against individuals. I see it every now and then, I do, but not nearly as often as when clients are fearful of it. If there's 100 clients where they say, hey, I think this is going to happen, I'm worried about this. I mean, it's usually less than 10 where it might actually happen, and probably even less than 5 in most situations. Again, every now and then it does occur, and we handle those cases. And like I said a few minutes ago, sometimes those can be the best cases because they're so clear cut. It gives the employer no wiggle room and no real opportunity to excuse my language, BS their way out of what they did. You've got a long-term employee, been there for years and years and years, excellent employee, excellent reviews, makes a complaint, and then 2 days later is fired. I mean, all of a sudden in 2 days they become the world's worst employee? No, it doesn't make any sense. And so a lot of times when we're looking at claims from the employment law perspective, it's timing. Timing is very important to these things, and what progressed from one step to the other, and where that situation, that problem occurred. Let me just check my list here. I think that was all the questions I had from everybody else. Oh, one more that just popped up in here is somebody had a question about FMLA and maternity leave. So FMLA does typically protect maternity leave as long as you are an FMLA eligible employee and the company is large enough to be protected by the FMLA laws. When you come back from FMLA, the FMLA requires you to be put in the same or similar position. So we do see cases, not always with maternity leave, but where, hey, somebody comes back and then within, you pick a number, 1 to 2 to 3 weeks, they are fired. First thing we have to look at is, okay, did something happen, right? When you came back, like, did something go wrong and somebody really screwed up something that was worthy of termination? If not, and we start looking at, okay, well, what's the story? What's the reason for this termination? We want to look at, what do the termination papers say? What did the boss or whoever the employee spoke to, what did they say about it? And in essence, we want to start picking holes in their theory about what they're saying happened. I had a case involving FMLA where my client was fired. It was either the day he came back or the day after. I mean, within 2 days max of it. And they came up with this whole laundry list of excuses, basically every single one of which was prior to the FMLA leave. And our position was, well, hey, these things all happened 9 months ago, 6 to 9 months ago. You didn't fire him then. Why now is it a problem? Especially somebody in this situation who had been with the company a long time. He had been there 5 or 6 years approximately. Doesn't make any sense. The story the company is telling doesn't make sense. That was luckily a successful case. We were able to get it resolved just prior to trial. I did see a question here about, are you allowed to get information from the company? That's a tricky one. Companies do not have to give you your pay records, your personnel file, or anything like that. Now, if we get into a lawsuit, yes, they do under the subpoena power that we get once we actually file that lawsuit. But if you're just asking for these things, or let's say you've been terminated and you're trying to go back and request these things, not necessarily. They don't have to give it. Just like, believe it or not, companies don't actually have to give a reason for termination. They can just say you're terminated. Now, that doesn't mean they can discriminate, but it's on us then to prove there was discrimination. So sometimes people will call, hey, they didn't even give me a reason. They just said I'm fired. That's when we have to start piecing together kind of what happened and using witnesses or other information that we can gather. So I wish the law was a little different. It'd make my job a heck of a lot easier if we were allowed to get all that information we requested from the company. But they don't always have to. I will say, in my experiences in the cases we handle, a lot of companies will provide information to us. Maybe not everything we asked for, which is always suspicious when they give me 9 out of the 10 things I asked for. What does that one show that they don't want to give me? But oftentimes they will share some information. Sometimes they don't. And if that's the case, okay, then you know what? We're likely going to have to move forward with a lawsuit, and we'll get the information then. We'll get it some way, somehow, one way or the other. question just came in. Are companies allowed to keep you from clocking in and out? They should not. The Fair Labor Standards Act, that is the basic federal overtime law, requires companies to keep accurate records of when you clock in and out. And they're supposed to pay you for all time. So if you come in, the boss says, hey, again, I'm making scenarios up here. You come in at 7:30, hey, start working, but don't clock until 8. Or the opposite. Hey, I need you guys to clock out and keep working, shut down or whatever, but we need to keep our labor budget low, or we need to keep our labor hours low. No, that's not proper. That is not illegal. You need to be paid for all the time you worked. Now, let me change the facts. Companies can require you to clock out and go home and say, hey, you know what? I want you to be done working for today. Companies don't have to pay overtime. If they want to not pay overtime, then they have to completely relieve you of work. So if it's, hey, you're at your 40 hours for the week, it's 3 o'clock on a Friday, clock out, go home, enjoy the weekend. There's nothing wrong with that. That is proper. But if they are stopping you from clocking in and out, and it is costing you time and money, that is illegal, yes.
Ryan, I think we covered most of the questions that we had in advance. So we could make a last call for questions right now if anybody has any. If not, just FYI, everybody, there will be a recording of this that will be emailed to you probably early next week or tomorrow if we can get it turned around quick enough. And you can always find us, ask more questions at forthepeople.com.
Absolutely. And I did just see somebody just typed up there on a chat about they know they were shorted some money. I'm going to type my email address here into the chat. Don't hesitate to reach out to me directly, and I will gladly take a look at these situations or get one of my lawyers on it to take a look and see if it's something that we can help you with.